Tribunal in the matter of the Tower 1 Forge Limited and the Commissioner's Right.
Good morning.
Good morning. I appear on behalf of the taxpayer appellant, together with Mr. Sam Brodsky. My learned friends James Henderson and Arthur Wong appear for the respondent commissioners. So this appeal is concerned with the proper interpretation of two provisions of Part 4 of the Finance Act 2003, which contains the Stamp Duty Land Tax Code. And the two provisions in issue are Section 54(4)(b) and Section 75(a). The proper interpretation of Section 54(4)(b) forms the subject matter of the appellant's two grounds of appeal, and I am going to address you on both of those. The proper interpretation of Section 75(a), which only arises in the event that I succeed on at least one of my grounds of appeal, is the subject of the respondent's notice, and Mr. Brodsky will address you on that tomorrow. But apropos of that, may I check whether the court is content with the suggestion in the Revenue's letter of yesterday, and which I hope you received, that in the event that it becomes relevant, the issue of the chargeable consideration on a notional distribution of the property, which has not hitherto been an issue in the appeal, be addressed by way of written submissions after the hearing.
That's the Section 75(a) 5 point.
It is, yes.
And you are content to deal with it in that way?
We are, yes.
And have you discussed any timetable for those?
We haven't, but
submissions?
we could do that at the lunch break if that's...
Well, I think that we'd be interested to know what your timetable for that is, and then we will have to see what we think is appropriate, given how it might fit in to actually writing these judgments. So if we hear what you say after the short adjournment, and then we will assess where we should be in relation to timing.
Very well. Thank you.
I just mean that, of course, we want it to be a suitable amount of time and convenient for you, given that it's a new point, but on the other hand, it has to fit into the scheme of things in actually
absolutely
producing judgments.
Yeah, and the point only arises if it sort of assumes that you're with us on at least one of our grounds, but against us on the question of the availability of group relief on the notional transaction. So it only arises in that eventuality, and yes, that you agree that it would be a distribution. So it's it may be irrelevant, the point. So starting with the relevant facts, these are set out in the FTT's decision at paragraphs 5 to 22, and if I can please highlight the key parts to you. So in paragraph 8,
I'm sorry, just give me a moment to find it.
Do you want are you working from the core? Or have you
yes,
ripped it
so
off?
I've got it. Yes.
So at paragraph 8, you can see in 1997, St George South London Limited, which is a company within the Berkeley Group, acquired the freehold interest in a site known as St George's Wharf. It's not recorded in the decision, but it's not in dispute that SDLT was payable and paid on that acquisition. Then in paragraph 9, in 2000, SGSL sold the site to its immediate parent, St George plc, but retained the legal title which it held as bear trustee for St George. In paragraphs 12 and 13, St George then developed the site as a 50-storey residential building known as the Tower, and as the development was entering its final phase in February 2010, it was considered commercially advantageous to transfer the tower into a separate legal entity so as to ring-fence risk and provide financing flexibility. So with that commercial objective in mind, and to ensure that there would be no adverse tax consequences of transferring the tower to a separate legal entity, the group approached its tax advisors, PwC, who advised that in fact, if the tower was transferred by means of a sequence of transactions rather than directly, there would be a tax advantage in the form of a tax-free step-up in the carrying value of the tower from book value of roughly 30 million to market value of roughly 200 million. And then you can see at paragraph 14, the step plan which PwC devised pursuant to that advice, and that was then executed on the 5th of July 2011, and you can see in paragraph 18 that that involved or included 2 chargeable land transactions. The first was the grant of a 999-year lease in respect of the tower by SGSL to Barclay 64 Limited, which was another company within the Barclay Group, for a premium equal to the book value, say £30 million odd. And then the second chargeable land transaction took place following the acquisition of the entire issued share capital in B64 by the appellant, which was the SPV established specifically to hold the tower. And that was a transfer of the tower by B64 to the appellant, again for a consideration equal to book value of £30 million odd. And then over the page, over my page anyway, paragraph 20, you can see that what then happened was B64 and the appellant submitted their SDLT returns, and in each case claimed group relief under Schedule 7 of the FA 2003. And it's worth just turning those up, which you'll find in the supplementary bundle, starting at page 5. And the point I want to highlight to you is you'll see question 4 there, effective date of the transaction, and that's given as 5th of July 2011. And you'll see the same on page 14, which is the appellant's return. So the SDLT1, which is the tax return for chargeable land transactions, doesn't ask for a specific time of at which the transactions took place, and that we say is because the SDLT code operates simply by reference to the effective date, the date of completion on which the transaction takes place, and not by reference to a specific point in time on that date. So the SDLT ones themselves are undated, but at pages 23 and 24 of the supplementary bundle are the SDLT 5s, which are the certificates of receipt, which are generated automatically and immediately upon the filing of an SDLT1 electronically. And you can see from page 23, it's the fourth, the second box down, date of issue, 7th of July 2011. So the returns were made 2 days after the effective date of the transactions. So what happened next was that the Revenue opened an inquiry into the appellant's corporation tax return and challenged the tax-free uplift in the carrying value of the tower. And the upshot of that inquiry, as is recorded in paragraph 19 of the FTT's decision, was that rather than giving rise to this tax-free uplift, in fact, the transactions gave rise to an immediate chargeable gain of 170 million on which corporation tax was payable. the same time as that inquiry into the CT return, the Revenue also reviewed the SDLT position.
Sorry, they didn't open inquiry. Into
They
this,
didn't, no.
so-
They
which is why we have a discovery assessment.
exactly,
Okay,
yes.
thank you. So they reviewed it.
They
your
reviewed it
word.
rather not in an inquiry process.
Okay.
Yes. So they reviewed the SDLT position, and you can see from paragraph 21 their conclusions as a result of that review. And they concluded, as regards the grant of the lease by SGSL to B64, in respect of which B64 had claimed group relief, that transaction should be disregarded pursuant to subsale relief, and so the claim for group relief fell away. And then as regards the transfer of the lease by B64 to the appellant, the existence of arrangements with a main tax purpose meant that group relief was not available. And so the result of those conclusions was that the appellant was assessed to SDLT in the amount of £8 million, pursuant to the deemed market value rule. And that 8 million is basically 4% on 200 million. So we say it follows from those conclusions that each of the claims for group relief which were made were invalid and ineffective. They were invalid because the transactions formed part of arrangements with a main tax purpose, which meant that group relief was not available. And they were ineffective because in neither instance was the relief claimed, in fact, obtained. So turning next to the legislation, which starts on page 34 of the authorities bundle. Can we start, please, with section 45, which is on page 39, what is commonly referred to as subsale relief. Now, this provision applies where there is a contract for a land transaction and then an assignment or a subsale of the subject matter of that contract. And so to avoid a double charge to SDLT on the completion of both of those contracts, subsection 3 provides that the original contract is to be disregarded. So that was why the claim for group relief by B64 fell away in this instance. If the grant of the lease was to be left out of account, then it followed that so too was the claim for group relief in respect of it. However, and what we know from the FTT's decision is that that conclusion was erroneous. There wasn't, in fact, a subsale here. So what the Revenue ought to have done was assess B64 for SDLT on the £30 million premium payable for the grant of the lease. And that's paragraph 80.
Or possibly on the market value of the lease.
Well, the grant of the lease would have been a distribution, in our submission. It would have been a distribution.
Okay, there's a lot of assumed distributions going on in this case. I know one's been conceded, but it doesn't necessarily follow, does it, that every single transaction that we're looking at is a distribution?
Well, the rationale for why it's been conceded in this case is the Aveling Barling case, which is it's a sideways distribution, and that was a case where there was a distribution to a sister company.
All right, yeah, I mean, that case has been affected by subsequent legislation, which we've not been taken to, but
In the Companies Act.
in the Companies Act,
Yes.
I just want to sound a note of caution that I have speaking for myself, I have a concern about some of these labels of distribution being applied. I mean, the Companies Act, basically the effect of the Companies Act, can't remember the section number, but says if you had positive distributable reserves, then any distribution is zero in amount, broadly, if the transfer is at least at book value, which rather sounds to me like no distribution. So I'm just a little bit concerned about assuming that things like the lease grant, which you're just talking about, would have been a distribution.
Well, I think if it has to be a distribution in the sense, in the Companies Act sense, it wouldn't be a distribution, because that applies to transfers from a subsidiary to a parent rather than between sister companies, if you like. But
well, no one's suggesting, are they, that we look at the term distribution in the Corporation Tax Act, so we must be talking about company law distributions.
in the ordinary sense, yes, in the ordinary sense. And our case is that in the ordinary sense, a gift or a transfer at an undervalue between group companies is what is meant by distribution.
Well, let's find out in due course whether the extent to which that's common ground, and we might need to proceed on that basis if it is.
Yeah.
But to the extent you're asking this court positively to find that there's a distribution at any stage, I for myself have got some concern.
Okay. Well, if it's not, if it wasn't a distribution, then you're right that the SDLT charge that should have been raised against B64 would have been on the deemed market value, applying the deemed market value rule, which would have been on 200 million. But the real point is that is an assessment against B64. It's not an assessment. It can't be assessed against anybody else.
Presumably, again, this is not directly relevant, but one assumes that assessment was never raised.
No, it was not.
It presumably may well have been out of time.
Presumably so. And that's really what we say the error is in this case, is that the revenue took a view that subsale relief applied here, and they carried that through, when actually what they should have done, and what they often do, is raise an assessment in the alternative in the event that that subsale analysis was wrong, to say you, B64, should have paid SDLT on the 200. And it's not a legitimate process of interpretation to try to remedy that error by shoehorning the circumstances of the assessment in relation to the appellant into section 54(4)(b).
Okay, so you basically say they could have, if they understood the correct position, they should have issued an assessment against B64.
Yeah.
Rather than taking this approach.
Yeah.
You can also perhaps think about it the other way. What would the revenue say is the correct interpretation if they had, on section 54(4), if they had in fact denied the claim to group relief against, as far as B64 was concerned, and raised an assessment? Because if I understand their argument correctly, they should still be assessing under section 54(4) unless they're choosing to operate a concession.
Yes, but not at market value. If they'd unpicked the claim for group relief made by B64 and assessed B64, then that supersedes the claim for group relief.
Yeah.
And in that situation, it hasn't been challenged that there was an onward distribution by B64 to the appellant. So that would be a transaction in respect of which there wasn't a prior transaction in respect of which group relief had been claimed.
Well, but my point is that on the revenues approach, an unsuccessful claim to group relief, which is what this would have been,
Yes, is enough to
would be
disqualify
enough.
us. Yeah,
So
absolutely.
we're here from the revenue on that.
Absolutely. Well, and you'll hear from me as to why that's not correct. And that is looking at what is the purpose of 54.4b.
Yeah.
So you'll hear from me on that too. But yes, I appreciate that's the revenues case. So whilst it is true, as the revenue observe in paragraph 25 of their skeleton, that B64 hasn't paid SDLT, we say that's not because of its claim for group relief. It's because the revenue wrongly concluded at the end of their review that subsale relief applied and failed to raise an assessment in the alternative. So that's subsale relief. Then over the page, please, page 44 of the authorities, we've got section 50, which makes provision for the chargeable consideration and points you to Schedule 4, which is at page 118. And paragraph 1.1 says the chargeable consideration for a transaction is, except as otherwise expressly provided, any consideration in money or money's worth given for the subject matter of the transaction. So the general rule is that SDLT is payable on the consideration given, but there are certain exceptions to that rule, and the relevant one in this instance is section 53, which is on page 46. So this is an exception which applies to transfers to a connected company. And in that instance, as subparagraph 1, subsection 1a explains, the chargeable consideration shall be not less than the market value of the property. Now, in paragraph 26.2 of their skeleton, the revenue described section 53 as establishing a normal market value rule for transactions between connected companies. But in our submission, that is to overstate the position. And it is clear from the various exceptions and exemptions that it is in fact, section 53 is in fact a more closely targeted exception to the usual rule that SDLT is payable on the consideration, if any, given. So what we say section 53 is intended to target is the avoidance of SDLT by an individual gifting property to a company and then selling the shares in that company instead of the underlying property. And in that event, stamp duty on the shares at a lower rate would be payable rather than the higher rate of SDLT on the property. Or in addition, it targets a company sidestepping the clawback of group relief by distributing the property out of the group instead of selling the shares in the company to which the property was transferred with the benefit of group relief.
Sorry, would you repeat that? Sidestepping clawback of group relief.
By, instead of, I'll show you the group relief clawback in a moment, but it applies where property is transferred to a group company and group relief is claimed, and then within the specified period, the company leaves the group with the property. And so what Section 53, the deemed market value rule, is intended to do is stop companies from sidestepping that clawback by, instead of selling the shares in the company or the company leaving the group, the company distributes the property out of the group. And we say on any view, and I don't believe it's suggested, that the circumstances of the present case come within those, that intended target. And we say in particular, this is not a case where there has been any avoidance of SDLT on the disposal of the property or units in the tower when sold to third-party purchasers. And we say that's a strong indicator that the interpretation adopted by the FTT and the Upper Tribunal, which operates to bring the appellant within the deemed market value rule, cannot be right.
Sorry, can you say that again? I was thinking of something you said earlier, apologies. You're saying that the way it's being sought to apply in this case...
We're saying there's been no avoidance of SDLT. If Section 53 is essentially an anti-avoidance provision, you would expect it only to bite in circumstances where there is avoidance of tax. And here there hasn't been any avoidance of tax, because when the property was disposed of by selling the units to third-party purchasers, SDLT was paid in full on that. So full value SDLT has been already received in relation to this.
Okay, well, two observations on that. One is that Section 53 doesn't say it's an anti-avoidance provision. Another is, one of the difficulties with this case really is the fact that, at least in a group relief context, anti-avoidance is not limited to SDLT anti-avoidance. It applies to corporation tax anti-avoidance, which is essentially why we're here. So I'm just want to understand a bit better why you say that Section 53 should be interpreted only with SDLT avoidance in mind.
Well, because if you go back to the general position, which is that SDLT is paid on the consideration, if any, given for the property, and if an individual is free to gift or transfer at an undervalue their property to another individual, nothing wrong with that. You can choose to do that without incurring a SDLT charge on the market value. Companies are, I'm going to make this point when I come on to the exception for distributions, companies are also free to do that, subject to any risk of that producing an avoidance. So where a company is involved, there's an obvious risk if an individual transfers a property to a connected company, that they're doing that to sell the shares in the company. And if there is a risk of an in the case of an intra-group transfer, that would ordinarily be covered by group relief. Yeah. But with a connected company, if there's no, that's not really the risk. There's only a risk of an avoidance of group relief, as you'll see from the exception, in circumstances where it's possible that group relief might be sidestepped. Otherwise, a company is free to distribute, to gift property to a connected company. So you're right, it doesn't say, it's not described as an anti-avoidance provision, but we say that is the purpose of Section 53. It is targeting scenarios where, by virtue of the transfer to a connected company, there is a risk that SDLT will not be paid on the disposal of property which is enveloped in a corporate wrapper. Shall I move on to section
Yes, sorry,
54?
thank you.
Sorry,
Yes.
I didn't want to rush on if you had another question. So section 54 is at page 47, and that sets out the exceptions to the deemed market value rule. So the first two cases, case 1 and case 2, essentially concern transfers to a connected trustee company. And the reason why those are exceptions is because there can be no risk of the mischief that I've just identified materialising, because the trustee company has no beneficial interest in the underlying property. So if there was to be a subsequent sale of the trustee company, the purchaser of that company would not enjoy the beneficial interest in the property. And then the case 3 exception, which is the relevant exception in this case, applies to distributions of property. And we say that the purpose of the exception for distributions is to put gifts between connected companies on a par with gifts between individuals, so that SDLT is only payable on the consideration, if any, provided. So we say that the normal rule per section 54.4a is that gifts between connected companies are not the target of the deemed market value rule, and that is subject to the proviso in section 54.4b, which requires that it is not the case that the subject matter of the transaction has, within the period of 3 years immediately preceding the effective date of the transaction, been the subject of a transaction in respect of which group relief was claimed by the vendor. And as I've already said, we say that the purpose of that proviso is to prevent groups from sidestepping the clawback of group relief by, instead of the purchaser company leaving the group, it distributes the property to a connected company instead. And that being so, it follows in our submission that the target of the proviso is property in respect of which group relief has been validly and effectively claimed, because the clawback of group relief is predicated on a valid and effective claim having been made. If the claim is invalid or ineffective because group relief was not available, or because the claim was subsequently withdrawn, or has been challenged or superseded by assessment, then the clawback of group relief is not in issue. And we say there can be no question of the distribution sidestepping a clawback which is just simply not in issue.
And can I understand what you say in a bit more detail about why this is all about sidestepping a clawback of group relief?
Well,
Do you point to the 3 years?
yeah, and the claim, and it talks about group relief being claimed in the 3-year period, and we say that is pointing you to paragraph 3 of Schedule 7, which I'm about to show you, which is the clawback of group relief, where the company leaves the group with the property within the 3-year period. So what we say is that Section 54(4)(b) and paragraph 3 of Schedule 7 are basically two sides of the same coin. They are both intended to counteract an abuse of group relief by, in the case of paragraph 3, the conditions for exemption ceasing to be satisfied at a future point because the company has left the group. And in Section 54(4)(b), in the case where the property is distributed out of the group. And if you see them as two sides of the same coin, then it's natural to read 54(4)(b) as referring to valid and effective claims for group relief, because that is what paragraph 3 of Schedule 7 is concerned with. If there hasn't been a valid and effective claim for group relief, there's no question of any clawback. Other provisions kick in. The revenue's powers of inquiry, their powers of assessment, the amendment of a return to withdraw a claim. Those sorts of provisions are all engaged, and they are provisions which would be relevant. But paragraph 3 of Schedule 7 is not concerned with invalid and ineffective claims. It's predicated on group relief being available and claimed, and those conditions for exemption ceasing to be met at some future point. So group relief is provided for by Section 62, which is on page 57. And subpara 1 points you to Schedule 7, which provides for relief from SDLT. And then subpara 3 requires that any relief, subsection 1 points you to Schedule 7. Subsection 2 refers to Part 1 of that schedule, making provision for group relief. And subsection 3 provides that any relief under that schedule must be claimed in a land transaction return or an amendment of such a return. And so we say it's apparent from Section 62 that whilst a claim for group relief is a necessary component of group relief, it is not a sufficient one. For group relief to be available, the claim must satisfy, the claimant must satisfy the requirements set out in Part 1 of Schedule 7. And that's at page 129 of the bundle. So paragraph 1 provides that a transaction is exempt from charge if the vendor and purchaser are companies that at the effective date of the transaction are members of the same group. And then paragraph 1 goes on to explain what's meant by that. And then over the page, subpara 7, this paragraph is subject to paragraph 2, restrictions on availability of group relief, and paragraphs 3 and 4a, withdrawal of group relief. So the availability of group relief is subject to paragraph 2, which restricts the availability of group relief. And paragraph 2 sets out various restrictions, the first of which broadly concern the situation where, as at the time of the transaction, there are arrangements already in place for the company to leave the group. And then the restriction that we're concerned with here is in subparagraph 4A on page 131. Group relief is not available if the transaction A is not effective for bona fide commercial reasons, or B forms part of arrangements of which the main purpose or one of the main purposes is the avoidance of liability to tax. And as you've already pointed out, tax here includes income tax, corporation tax, CGT, as well as stamp duty. And that's why group relief was not available in respect of these transactions. So, notwithstanding the claims that were made, neither B64 nor the appellant, in fact, qualified for group relief. And then paragraph 3, at the bottom of page 131, deals with the withdrawal of group relief. So where, in the case of a transaction that is exempt from charge by virtue of para 1, so pausing there, we say the clawback of group relief is predicated on there being a valid and effective claim in respect of a qualifying transaction. If group relief is not available because the transaction is disqualified by paragraph 2, then paragraph 3 does not address that situation.
You say you can't withdraw something that didn't bite in the first place.
Exactly. We say invalid claims are instead provided for by the revenue's powers of inquiry and powers of assessment, which are in schedule, you'll find in schedule 10, which we don't have in the bundle, but I don't think they're contentious, and they're the ordinary discovery powers of assessment and powers of inquiry that you find elsewhere in the TMA and Schedule 18 of the Finance Act 1998. So we say what paragraph 3 is concerned with is transactions which are exempt under paragraph 1 pursuant to a valid and effective claim, and it goes on to provide that where the purchaser ceases to be a member of the same group as the vendor before the end of the period of 3 years, beginning with the effective date of the transaction, where over the page 132, at the time the purchaser ceases to be a member of the same group as the vendor, it holds the property acquired by the purchaser under the relevant transaction. So the mischief at which paragraph 3 is aimed is the situation where at the time of the transaction, at the time of the transfer of the property to the company, the conditions for group relief are satisfied, but at some subsequent point within the relevant period, they are no longer satisfied because the company leaves the group with the property. And we say if the premise of the clawback of group relief is that there is a valid and effective claim for group relief, then the premise on which section 54(4)(b) proceeds cannot be simply that there is a claim or was a claim. And that's because the purpose of 54(4)(b), as I've said, it's the other side of the coin, the same coin. Its purpose is to prevent the sidestepping of a clawback under paragraph 3 by distributing the property instead of the transferee company leaving the group. But just like paragraph 3, section 54(4)(b) is also predicated on there having been a valid and effective claim, which might otherwise have fallen foul of the clawback. And so we say, in particular, if the transaction was chargeable at the time because group relief was not available, that is not the mischief at which paragraph 3 or section 54(4)(b) is aimed. That is a mischief at which the powers of inquiry and assessment are aimed. And then finally, can I show you section 119, which is on page 111, which explains what is meant by the term effective date. Except as otherwise provided, the effective date of a land transaction for the purpose of this part is the date of completion. And then subsection 2 sets out various other provisions where the effective date means something else. And section 54(4)(b) is not amongst them. So turning then to the grounds of appeal, the issue before you is whether the transfer of the tower lease from B64 to the appellant satisfies the requirements of the case 3 exception. And that issue turns solely on the requirements of the proviso in section 54(4)(b) and those requirements being satisfied. Now, the revenue contends, and the FTT and the Upper Tribunal agreed, that those requirements are not satisfied for 2 reasons. First, because the tower lease was the subject of a transaction in respect of which group relief was claimed by the vendor, B64, and that's the correctness or incorrectness of that is our first ground of appeal. And secondly, because the transaction in respect of which group relief was claimed took place within the period of 3 years immediately preceding the effective date of the transfer, the distribution to the appellant, and that's our second ground of appeal. And I'm going to take the grounds in that order.
And just to be absolutely clear, leaving to one side section 75A, you can win on, you would succeed if you succeeded on either ground.
Yes.
You don't need both.
I don't need both, no. So I want to start with the reasoning below and with the FTT's decision, and we can pick it up at 74. The FTT says section 54(4) refers to a prior transaction in respect of which group relief was claimed by the vendor. It refers to group relief having been claimed by the vendor, does not refer to group relief having been validly claimed by the vendor, a qualification that could easily have been added to the word.
I'm so sorry, where are you reading?
I'm sorry, I'm in paragraph 74.
I've got page 74. That's one. You're in the
Page
FTT.
139.
It's page 139 of the core.
I do apologise. Yeah.
So in paragraph 74, the FTT's approach is to just look at the literal meaning of the words used. And that, we say, is the essential error. In paragraph 75, it says that literal interpretation establishes a simple and workable test. And then at paragraph 76, it rejects the appellant's interpretation on the basis that it would be difficult or impossible to apply, because as at the time of the transaction, the company may not know if an earlier claim for group relief was valid, or there might be a pending dispute. And then in paragraph 78, it concludes that the application of the deemed market value rule in circumstances where the claim was invalid and the company does not ultimately take the benefit of the group relief claimed, for his instance because the group relief was ultimately disallowed, is not so inherently inequitable a result as to indicate that Parliament could not have intended it. And so as a result, it concludes at paragraph 90 sub 3 that on the facts of the case, the terms of the proviso were not met by dint of the claim that had been made by B64. So that's what the FTT says. The Upper Tribunal's decision, the discussion begins at paragraph 140, which is on page 95 of the core, where it starts by correctly summarising the guidance of the Supreme Court in Rossendale. And I'm going to take you to Rossendale shortly. And then at paragraph 153, which is on page 98, I'll just ask you to read that paragraph yourselves, if I may. So again, the focus is on the literal reading of the words used. Then at paragraph 156, the Upper Tribunal accepts that a literal interpretation means that the case 3 exception is unavailable, even where the purchaser doesn't ultimately enjoy the benefit of group relief, whether that is because the claim is withdrawn or the revenue successfully challenged the claim or otherwise. So it accepts that that is the upshot of the literal interpretation. And then at paragraph 157, again, I'll just ask you to read that paragraph to yourselves, please. So again, the focus is on the literal reading. So we say, notwithstanding some slight differences of detail in the reasoning below, the errors are essentially threefold. First, we say that the FTT and the Upper Tribunal failed to identify the class of facts at which section 54(4)(b) is aimed, and consequently, that the facts of the present case do not fall within that class. Secondly, we say that the tribunals below wrongly categorised the appellant's interpretation as requiring words to be read in. And thirdly, we say that they wrongly concluded that the consequences of the competing interpretations favour a literal interpretation. So the correct approach to statutory interpretation is now very well established and has been restated very recently by the Supreme Court in Rossendale, which is at page 331 of the bundle. So the question in Rossendale was whether an SPV with no assets and no business could properly be regarded as the owner of unoccupied commercial premises over which it had been granted a lease by the owner of that property in order to avoid the payment of non-domestic rates on unoccupied business premises. And the answer turned on whether the SPV, which had the legal right to possession, could be regarded as the person entitled to possession within the meaning of section 65 of the relevant act in that case. we can pick it up at page 345, paragraph 15. So after referring to various dicta on the Ramsey principle, the court says this: in the task of ascertaining whether a particular statutory provision imposes a charge or grants an exemption from a charge, the Ramsey approach is generally described as involving two components or stages. The first is to ascertain the class of facts, which may or may not be the transactions, intended to be affected by the charge or exemption. This is a process of interpretation of the statutory provision in the light of its purpose. The second is to discover whether the relevant facts fall within that class, in the sense that they answer to the statutory description. So the aim of the interpretative exercise is to identify the class of facts intended to be affected by the provision, the mischief at which the provision takes aim, by reference to the context of the statutory scheme as a whole. And that is clear from what is said in paragraph 16. Both the interpretation and the application share the need to avoid tunnel vision. The particular charging or exempting provision must be construed in the context of the whole statutory scheme within which it is contained. And then in 17, likewise, the facts must also be looked at in the round. So we say, adopting that approach here, the class of facts intended to be affected by the proviso in 54(4)(b are distributions of property which have, within the specified period, enjoyed the benefit of group relief, and where, if instead of distributing the property, the company had instead left the group with the property, group relief would have been withdrawn. And we say, viewed in context, when 54(4)(b refers to property in respect of which group relief was claimed, it can only properly be taken to be a reference to group relief which was validly and effectively claimed, because it is only in those circumstances that the risk of clawback arises. By contrast, it must follow from the literal interpretation of the proviso that the class of facts intended to be affected includes any distribution of property in respect of which a claim for group relief was made, but which was invalid or ineffective. And that would include a claim for group relief which is subsequently withdrawn by amendment of the return, or a claim for group relief which was not available, including where HMRC have raised an assessment for the SDLT payable. In other words, the literal interpretation proceeds on an assumption that the intended target of 54(4)(b is wider than the intended target of the clawback of group relief. And in our submission, there is no contextual basis to support that assumption. And it is, moreover, difficult to see why section 54(4)(b should be interpreted as applying more widely. If there's no question of sidestepping a clawback of group relief that would otherwise have arisen if the company left the group, because the claim was invalid or ineffective, why is that scenario the concern of section 54(4)(b? Invalid and ineffective claims are the concern of Schedule 10. the revenue's powers of inquiry and assessment. And we say it is telling that neither the FTT nor the Upper Tribunal, and indeed the revenue themselves, are able to offer or unable to offer any explanation as to why the proviso should be interpreted in that way, other than by pointing to the literal meaning of the words. We say
Can I
paragraph...
just ask, would there be any purpose, and if so, what, of the 3-year period in 54(4)B, if one were looking at the literal interpretation of a claim valid or invalid? If one is covering a claim which is invalid, what relevance would the 3-year period have?
Well, perhaps the relevance of it would be to restrict the punitive nature of the of the proviso. But we say that the 3-year period is pointing you to paragraph 3, the paragraph 3 clawback. It is aligning the position with that. And neither paragraph 3 nor 54(4)B are, we say, compliance provisions. They're not intended to police the position if there's been an invalid claim. What they are intended to do is simply stop the abuse of group relief where, after the transaction, the conditions for exemption are no longer met.
Just a slightly different way of asking that question, but just to clarify, the reference to 3 years, could it point to anything other than the paragraph 3 clawback? I mean, you know, there's no other 3-year rule lurking somewhere that could be.
As far as
certainly that I'm aware of.
As far as I'm aware, not. And of course, the discovery assessment is by reference to 4 years. So it's not tying in with that. It's the only 3-year period that I'm aware of is the para 3 clawback.
Hence, you're saying 54(4)B points very clearly to paragraph 3 of Schedule 7.
Yes.
And it can't be essentially.
It's not pointing anywhere else.
It's not pointing anywhere
Yes.
else. That's what you say.
Yes.
Thank you.
So, having identified the class of facts to which the proviso was intended to apply, we say that the circumstances of the present case do not come within that class. The tower lease did not enjoy the benefit of group relief because B64's claim for group relief was invalid and ineffective. And in particular, the fact that B64 didn't actually pay SDLT on the grant of the lease is not because of its erroneous claim. It's because the revenue treated that transaction as eligible for subsale relief and failed to raise an assessment in the alternative. And that is not a scenario at which Section 54(4)B is aimed. So that is how we say the interpretative exercise should have been carried out, and accordingly that the facts of the present case do not answer to the statutory description because group relief was not validly and effectively claimed, which is what the proviso purposively construed requires.
Do you need validly and effectively? For example, let's say the group relief claim was allowed through, but it's common ground now that it shouldn't have been.
Then it wouldn't be.
Then you could see this might be a situation where the clawback provision could apply.
Well, if the claim is invalid, clawback is not an issue, full stop, because you are not. Paragraph 3 requires the transaction to be exempt under paragraph 1. So if it is invalid because paragraph 2, a paragraph 2 restriction, or maybe the group relationship wasn't in existence at the time, But for whatever reason, if the claim is invalid, then paragraph 3 doesn't care. It's Schedule 10 that cares about that.
Okay, so in that case, you'd say the revenue should, if they could, go back and assess the original
Absolutely.
transaction. And if they're out of time, they're out of time.
Absolutely,
That's what
yes.
Schedule 10 does.
Absolutely, yeah. But you can have a situation where the claim is valid, and then up to a year later, for whatever reason, that claim is withdrawn by amendment of the return. So you'd have a valid claim, but you've actually changed your mind and you've withdrawn it. So the claim that you made was valid, but in the event it was ineffective. And we have a situation where the claim was invalid and it was ineffective because the revenue concluded that subsale relief applied.
Is the effect of your argument that the word claimed is really to be regarded as meaning obtained? Or is it something short of that?
Well, as I put it, as validly and effectively claimed, you certainly have to have obtained group relief, otherwise you can have no clawback of it. But if obtained is might be taken to mean, wrongly obtained. Yes, so that's why I prefer
Successfully claimed.
Yes, and legitimately claimed. Yes,
But, because you're tying it in with paragraph 3, which, as you said, assumes that the transaction was properly exempt,
yes,
as in properly qualified for group relief in the first place.
yes,
I understand better now why you're saying both validly and effectively.
yes,
And that if you get it but you weren't in fact entitled to it, the proper course, you say, would be an assessment of the original
absolutely.
transaction.
That is a mischief at which Schedule 10 is
Yeah.
targeted. That's not a mischief at which paragraph 3 is targeted, nor we say 54(4)(b). So we say the second error in the decisions below is that they wrongly categorise the appellant's interpretation as requiring words to be read in. And in our submission, the appellant's interpretation doesn't involve reading words in. It simply involves giving a purposive meaning to the words used. So purposively construed, property in respect of which group relief was claimed should be taken to mean property in respect of which group relief was validly and effectively claimed. And to illustrate that point, that we're not asking you to read words in, can we please return to Rossendale and the Supreme Court's reasoning at paragraphs 47 to 49 on page 354. So at 47, the court says there can be no doubt that the definition of the owner of a hereditament in section 65(1) of the Act as the person entitled to possession of it is to be interpreted as denoting, in a normal case, the person who, as a matter of the law of real property, has the immediate legal right to actual physical possession of the relevant property. And then over the page, between A and B, furthermore, such an interpretation generally accords with the legislative purpose of imposing the liability for business rates on the person who controls whether the property is left unoccupied and on whom the legislation is intended to place an incentive to bring the property back into use for the benefit of the community. In the unusual circumstances of this case, however, identifying the person entitled to possession in section 65(1) as the person with the immediate legal right to possession of the property would defeat the purpose of the legislation. As we have explained, the schemes were designed in such a way as to ensure that the SPV to whom a lease was granted had no real or practical control over whether the property was occupied or not, and that such control remained at all times with the landlord. in our view, Parliament cannot sensibly be taken to have intended that the person entitled to possession of an unoccupied property on whom the liability for rates is imposed should encompass a company which has no real or practical ability to exercise its right to possession. So what the court is explaining there is that ordinarily the person entitled to possession will be identified by the person with the legal right to possession under the law of real property. But that is, if you like, having the legal right to possession is a necessary but not a sufficient requirement. What the legislation is looking for is the person with real or practical ability to exercise that legal right. And so what it is saying is, when the legislation refers to the person entitled to possession, it's not just a case of pointing to where the legal right to possession lies. It's also looking for real and practical entitlement to exercise that right. And we say, just as the reasoning of the Supreme Court in Rossendale doesn't involve reading words in, it simply involves giving a purposeful meaning to the words used, the words entitled to possession. So too, the appellant's interpretation here simply involves giving a purposeful meaning to the words has been claimed and reading them as referring to valid and effective claims. And so then we say the third error in the decisions below is that they wrongly concluded that the consequences of the competing interpretations favour the literal interpretation, when in our submission they in fact favour the appellant's interpretation. So as far as the literal interpretation is concerned, it results in a charge to SDLT on the market value, even if the claim for group relief is invalid and ineffective. So as a result, if a claim is made and then it's subsequently withdrawn by amendment of the return, or the claim is subsequently disallowed, the proviso will nonetheless be breached. And the FTT concludes that that is not an outcome which is inherently inequitable, but we say with respect, there is no good reason for imposing the deemed market value rule in cases where group relief was claimed but was not ultimately enjoyed. And indeed, the Upper Tribunal, we say, was right to acknowledge that that is the upshot, and one might infer that they were uncomfortable with that upshot. Or certainly the Upper Tribunal acknowledged that in cases where a claim for group relief is subsequently withdrawn by amendment of the return. And if that is right, that group relief cannot sensibly be regarded as having been claimed in circumstances where it is subsequently withdrawn by amendment of the return, then so too must the proviso be regarded as satisfied, where the claim for group relief is ultimately not enjoyed because the revenue raised an assessment, or as in this case, they decide to confer subsale relief instead. One such example where group relief is claimed but not ultimately enjoyed is where the group relief is clawed back under paragraph 3, and that is a scenario which is recognised in the Revenue's manuals at page 595, which is the section SDLTM 30220. which deals with the deemed market value rule. And over the page on page 596, the revenue say that it's not their intention that 54.4 should be prevented from applying where a group relief claim was made by the vendor but recovered under paragraph 3.
Sorry, I'm struggling to find the page. 596.
596, 595 and 596.
And you were reading on 596 from?
It's the high. It's got a line down the side. So it's not the revenue's intention that 54.4 should be prevented from applying where a group relief claim was made by the vendor but recovered under para 3. So even the revenue accept in that example, that group, that 54.4b cannot be read as applying, or should not be read as applying to that scenario. Now, in the revenue skeleton argument at 26 sub 6, they describe their manual as a limited concession made within their powers of care and management. But what they don't go on to explain is what is so special about that specific scenario in contrast to, say, the scenario in respect of which group relief was claimed and the claim was subsequently withdrawn, or the scenario in which group relief was claimed and then subsequently disallowed. And in our submission, there is no qualitative distinction between those scenarios. What is common to all of those scenarios is that group relief has not been enjoyed.
Well, in fact, the scenario that's posited in the Revenues Manual is one where you could say, well, there really has been a valid and effective claim for group relief. It's just being clawed back later.
Yes, because the circumstances, the conditions for exemption no longer apply, but they did apply at the time, yes. So we say, if, as the revenue contend, the statement in their manuals is a limited concession, then its effect is to create unexplained, unjustified, and arbitrary distinctions between qualitatively similar scenarios. And with respect, that is not an appropriate use of the revenue's care and management powers. In our submission, by far the better explanation of what is said in the revenue's manuals is that it is illustrative of their recognition that it isn't simply enough for a claim to have been made if the company hasn't in fact enjoyed the benefit of group relief because it was clawed back or because it wasn't available, then the deemed market value rule doesn't apply.
So outside of this is slightly odd language. HMRC's intentions about what the statute provides. Is this a form of words that one sees in concessions?
It's not. So this is really the revenue's practice. It's meant to articulate their understanding of the position. So it's not binding on you. It doesn't have legal force.
No, they say it's just a concession.
But they say it's a concession.
Is this form of words about their intention a standard form of words used when?
I'm not sure I could say it was standard form, but it's slightly unusual.
Probably aren't very many left.
No, it's slightly unusually worded.
It's not articulated as a concession.
No, it's not.
Although that's what's being said.
Yeah, that's right. And
there, as Will points out, the wording is slightly odd.
yes. Well, you have what I say about it. My submission is that it reflects. It is meant to. It is an example that recognises that what section 54.4b is really getting at is scenarios in which group relief has been enjoyed. And so if it doesn't apply where there's been a clawback, the same must be true if the claim is subsequently withdrawn by amendment of the return or disallowed, so that the benefit of group relief hasn't in fact been enjoyed. Because otherwise it would follow that even if the taxpayer has paid the SDLT in respect of which relief was claimed, either by amending its return or pursuant to an assessment, the deemed market value rule would nonetheless be triggered. And in our submission, that cannot possibly be right. So as far as the merits of the competing interpretations are concerned, we say that they fall squarely in the appellant's favour. Then as far as the practicalities of the competing interpretations are concerned, we say there's nothing in the appellant's interpretation that renders the proviso impractical or difficult to apply. In particular, at paragraph 24 of the revenue skeleton, they contend that it cannot be that the proviso is engaged and then disengaged and then re-engaged depending on events, such that whether or not the proviso is satisfied cannot be determined at the time the transaction takes place. But even on the revenues case, they must accept that regard can be had to events that take place after the distribution, because it is only by reference to B64's claim 2 days later that the proviso is an issue at all. So on any view, there's nothing wrong in looking at events that take place after the distribution transaction, which inform the answer to the question at the point in time at which the question arises. And let's imagine that in this instance the returns had been amended and the claims to group relief withdrawn. Is it really suggested that the appellant would not have been able to rely on the subsequent amendment of B64's return, but would instead be subject to the deemed market value rule? And in this instance, the question arises in the context of an assessment, the very premise of which is that the claims for group relief were invalid and were to have no effect. And we would respectfully submit that there is an air of unreality, not to mention unfairness, in the suggestion that there is any impracticality or difficulty in having regard to that fact simply because the error had not been discovered at the time of the distribution.
I suppose you'd say strictly the premise of the assessment is that the group relief claim on the second land transaction, the transfer to the appellant, was not available. But I think you must be saying that that premise necessarily would disqualify the first transaction from group relief for the same tax avoidance purpose reason.
Yes. Yes. And if the revenue are right, that no regard can be had to anything after the distribution transaction, then it would mean that if the revenue had also raised an assessment against B64, the appellant would nonetheless still be liable for SDLT on the market value of the property. And we say that simply cannot be right. So that is what we say in support of our first ground. And unless you have any further questions, I was going to move on to my second ground.
Thank you. Round two.
So our second ground of appeal concerns the meaning of the words within the period of 3 years immediately preceding the effective date of the transaction. And in our submission, those words are only capable of one interpretation, and that is because the words effective date are a term of art defined in section 119 as meaning the date of completion. And accordingly, the legislation can only properly be interpreted as referring to the period of 3 years immediately preceding the date of completion of the distribution transaction, which is the 5th of July 2011. And so the period is the period from 5th of July 2008 to the 4th of July 2011. Now, the upshot of that is to leave out of account any prior transaction in respect of which group relief was claimed, which takes place on the same effective date as the distribution transaction, a result which one might well describe as a surprising loophole, but that is the nature of loopholes. They are unintended gaps, lacunas, which arise because the draftsman did not have in mind a particular scenario, this particular scenario, at the time of drafting. And that is simply what has happened here. So it's not our case, as the Revenue suggest in paragraph 30 of their skeleton, that Parliament must be taken to have intended to create a window of opportunity that opens up from midnight the day before the distribution. Plainly, that was not the purpose of the provision, but it is in our submission the effect. And it arises as a result of Parliament having identified the relevant 3-year period as the period immediately preceding the effective date of the distribution. So the FTT and the Upper Tribunal grapple with this conundrum in slightly different ways. The FTT is at paragraph 71, which is page 139 of the core. Where the FTT observes that all transactions take place at a specific point in time, so the proviso will nonetheless be breached if the prior transaction takes place on the same day, even if only a few seconds or minutes beforehand. But the difficulty with that, as the Upper Tribunal succinctly explains in paragraph 163 of its decision, which is at page 99, is that it is contrary to the way in which the term effective date is used throughout the SDLT code, and it is used almost 200 times. Now, in none of those other instances can it credibly be suggested that the term effective date should be taken to refer to the specific point in time at which the transaction took place on that date. And indeed, it would be highly impractical and administratively cumbersome to interpret the term as referring to the specific point in time at which a transaction takes place. In particular, if the precise moment is the point at which time starts to run, then it must follow that the precise moment at which any other relevant transaction or event takes place will also be material. So it would therefore become relevant the precise moment at which the return is filed for the purposes of section 76. The precise moment at which a company leaves the group for the purposes of para 3 of Schedule 7, and the precise moment at which a prior transaction in respect of group relief was claimed for the purposes of 54(4)(b). Now, what is said in response in paragraph 35(5) of the Revenue skeleton is that this is unlikely to be more than a theoretical concern. But in our submission, that is simply not the case. If the precise day on which something takes place can be crucial, which was the case in 79 divorced couples, where the petitions for divorce were served on the anniversary, happy anniversary, rather than the following day, and were, as a result, premature, there is no reason to suppose that the precise moment in time at which some other relevant transaction or event takes place might not equally be crucial. Such an interpretation also runs contrary to the general rule, and it's common ground that the general rule is that parts of days are not to be taken into account in the computation of a time period by reference to a particular date or event. And we cited a number of authorities in our skeleton at paragraphs 71 to 73. But in light of that common ground, I'm not proposing to take you to those. The simple point I make is that on any view, to interpret the words effective date as referring to a specific moment in time on the date of completion would be contrary to the general position. So instead, the revenue rely on two exceptions to that general position, Campbell and Strangeways and Heath and Longman, as examples where the court has interpreted the word day or date as referring to a specific time on that day or date. And in our submission, Campbell and Strangeways and Heath and Longman are somewhat peculiar to their facts, but more importantly, neither was concerned with the interpretation of a term of art, which is used repeatedly and consistently throughout the legislative code as referring to a particular day or date. So in Campbell, which is at page 166, the question here was whether on a particular date the accused was guilty of keeping a dog without a licence, contrary to section 8 of the relevant act in that case, in circumstances where the accused had acquired a licence later on that same day, and which section 5 of the same act said should be taken to have commenced on that day. And you can see from the head note, held, an offence had been committed on the relevant date and the subsequent licence operated only from the time when it was granted. And the reason for that is explained on page 168. Towards the bottom of the page, 9 lines up. The provision that the licence shall commence on the day does not necessarily mean that it shall begin at the first moment of the day, but that it shall not go further back than that day. So that was what the provision was getting at. So nothing in the use of the word day required the licence to be regarded or treated as if it had been granted at the beginning of the day. And so the consequence was that the offence in section 8 was committed, notwithstanding that later in that day a licence was subsequently acquired. So in other words, both the commission of the offence and the subsequent acquisition of the licence were capable of taking place on the same day for the purposes of the Act. Longman is at page 204 of the bundle. And the issue in this case was whether the employees in question were on strike on the date of their dismissal, because if they were on strike, that would preclude a finding of unfair dismissal pursuant to section 26 of the relevant act. And you can see the decision in the headnote there held. Once an employer had been informed that a strike was over, he no longer required the protection afforded by section 26. Accordingly, in 26.1, the word date should be construed as meaning at the time, so that if on any given date an employer was told that a strike was over, he was not free during the rest of that calendar day to dismiss those who had taken part in the strike without the risk of it being held that he had acted unfairly in so doing. So the court gets to the answer by construing the word date as meaning at the time, but the essence of the reasoning is that the statutory protection afforded by section 26 can only be justified if the employees are on strike throughout the date of dismissal. It's not enough just to point to an earlier point in the day as sufficient. So neither of those exceptions, we say, are analogous to the legislation at issue in this case, where the words are in issue are effective date, and where that term is a term of art.
Can I just ask you, you made a lot in ground one of reading the exception in 54.4b with paragraph 3 of Schedule 7, the clawback provision, which, as you point out, has a 3-year rule.
Yes.
Looking at paragraph 3, there wouldn't appear to be any equivalent loophole. You look at it from the other perspective, but if you just postulate, and it may be very difficult in practice, you had a group relief claim and then the transferee actually left the group on the same day. Yes, okay, put to one side whether there were, let's say there weren't arrangements in place. There was a valid group relief claim. Company leaves the group later on the same day. I don't think anyone would doubt that group relief would be clawed back.
That's correct. Yeah.
Because the time period there is expressed as leaving the group before the end of the period of 3 years, beginning with the effective date.
Yeah.
So I see the difference in language, but my question really relates to the fact that on ground one, you're tying the, if I may say, tying the provisions together.
Yes.
Quite carefully and applying a purposive interpretation.
And now I'm decoupling them.
Yes.
Yeah. So the answer to that is that the 3-year periods, they clearly reference one another, but in the paragraph 3 clawback, that is a forward-looking 3-year period. So it begins from the effective date of the transfer.
Yes.
And the period is specified to include that day, and then you look forward 3 years. In section 54.4b, it's a backwards-looking provision. And because it is expressed as the 3-year period immediately preceding the effective date of the distribution transaction, the effect of having articulated the period in that way is that you leave out of account the effective date of the distribution transaction. And as I said, we have to accept that is a loophole. That is an unintended effect.
The mirror would have been to use the words ending with, I guess.
The mirror would have been to use the words and including. In the 3-year period immediately preceding and including.
That is the same as ending with.
Yeah, but anyway, yes, there would need to be a change in the wording.
Or you omit, as the Upper Tribunal said, you omit the words effective date of, and you just focus on the transaction.
Yeah.
Which is sort of surplusage, a legislative mess up.
Yeah.
The court concludes that.
Yeah, and I'm
intention
going to come.
wasn't given
Yeah.
effect by the inclusion of those words.
Absolutely, I'm going to come on to that. But my essential submission is that that is not a process of interpretation. That's a process of ignoring the words. So, and that is not permitted. So,
Well, courts do on occasion correct words where they think something's gone wrong.
and I'm also going
You're going to go
to
on
come on to that if I
Yes.
may, because the example that has been given is the Binks case, and I'm going to address you on that as to why it's not appropriate in these circumstances to read words in either. So I say it's not appropriate to ignore the words that have been used as if they just simply didn't appear, and it's not appropriate to read words in. So to read in my example, and including the date of the effective date. But for now, I just want to stick with my response to the FTT's reasoning, which is you should be looking at an effective time, rather specific time on the effective date rather than the effective date. And the other, so the revenue rely on Campbell and Longwood and Longman. They also rely on the shorter OED definition, which is at page 599. The first definition of which is of date is the day of the month, the month, or the year of an event, the time or period at which something happened, or the time at which something is to happen. Now, that wording, the time or period at which something happened, cannot sensibly be taken to mean that on a date, on a particular date, the word date is a reference to a specific point in time. What that wording or that definition is intended to capture is the use of the word date to refer to a longer period than one day. So, for example, the date of the Norman conquest is 1066. Doesn't mean, cannot properly be taken to mean that the word date, as a matter of ordinary language, can be used to refer to a specific point in time on a particular date. So we would respectfully agree with the Upper Tribunal at paragraph 163 that when it says that the words effective date cannot properly be interpreted as a reference to the particular point in time at which the distribution transaction took place, because that is a term of art, the meaning of which is the date of completion, which in this instance is the 5th of July 2011, and that is a term of art used over and over again throughout the code as a reference to the particular date and not the particular time on that date. So turning then to the Upper Tribunal's approach, and as my Lord has just mentioned, it's page 99, paragraphs 159 to 162. In summary, the Upper Tribunal concludes there is no policy reason why a transaction which occurred earlier on the same day as the distribution should not be caught when a transaction which occurred the week before or 2 years before would be. the outcome whereby a prior transaction on the same day falls to be left out of account is absurd. And the words immediately preceding and the explanatory notes to the Finance Bill 2003 demonstrate that the transactions immediately before the distribution were intended to be caught. And so therefore it concludes at paragraph 162 that the words should instead be read as 3 years prior to the transaction itself. And as I've already mentioned, we say that the insuperable difficulty with that is that instead of interpreting the words effective date, the Upper Tribunal is simply ignoring them, and that is not a permissible approach to statutory interpretation. Indeed, if that were a permissible approach, it is difficult to imagine how there could ever be a loophole. If you could simply read around the words, ignore anything inconvenient, you would never end up in a situation where there would be a loophole. So that the mere fact that there's no policy reason for excluding transactions which take place on the same effective date, that the outcome is absurd, is not a basis on which to ignore the statutory wording. Loopholes can, and not infrequently do, arise, particularly in the context of highly prescriptive legislation, like the SDLT Code, a point which is acknowledged by the Supreme Court in the Project Blue case, which is in the authorities bundle at page 273. So the question in Project Blue was whether the combined effect of section 45 subsale relief.
I'm so sorry, that's 273.
It's 273 of the authorities.
Tab 16.
Thank you. Yes.
So the question in Project Blue was whether the combined effect of section 45 subsale relief and section 71A alternative property financing relief was such that none of the transactions which resulted in a sale of Chelsea Barracks to Project Blue were chargeable to SDLT, a surprising and anomalous result if ever there was one. Now, ironically, it was the revenue arguing in Project Blue that the legislation indeed produced that loophole. They described the SDLT Code as a patchwork of provisions prone to lacunas, and the majority of the Supreme Court agreed. So picking it up at paragraph 23 on page 283, Lord Hodge says, I recognise the difficulty in interpreting the legislation which has been subject to repeated incremental amendments and additions since 2003, as Parliament has struggled to optimise this new tax. Then over the page 286, paragraph 31, a consideration which influenced the Court of Appeal in reaching its view on section 71A2 was that Parliament could not have intended to leave transactions which involved a subsale financed by an Ijara arrangement, and thus fell within both section 45(3) and section 71A, free of charge for over a year before it introduced the anti-avoidance provision in section 75A. I see the force of this point. It is without question a legitimate method of purposive statutory construction that one should seek to avoid absurd or unlikely results. But SDLT was a new tax created by the Finance Act 2003, and as I have said, required repeated amendments to make it effective. It is not surprising that lacunas may have existed in the early years of a new tax. Now, perhaps it will be said that we are not now in the early stages of a new tax, but the answer to that is that this point has not arisen before. So this particular hole has hitherto gone unnoticed. It is only now that the hole is exposed. But more importantly, what is clear, we say, from the reasoning in paragraph 31, is that it is not enough just to point to an anomaly or an absurdity. That Parliament cannot have intended the gap does not absolve the court from engaging in the proper interpretative exercise. Now, of course, if it is possible to interpret the provision in such a way as to avoid that anomalous or absurd outcome, then the court should do that. But that will not always be the case, as Lord Hodge observes over the page in paragraph 34. The last two sentences in that paragraph. A purpose of construction will not always operate in favour of the revenue and against the taxpayer, as McNiven shows. Similarly, if there are lacunas in a statutory regime which enable tax avoidance, a purpose of interpretation may not always remove them, as the Court of Appeal's judgment in Mays shows. And that, we say, is the case here. A purposive approach cannot assist in closing the loophole because the purpose of the wording is simply to identify the time period within which the prior transaction must have taken place. And having specified that period so as to leave out of account any prior transaction which takes place on the same effective date as the distribution is not a problem that can be remedied by a process of interpretation. It is only a problem that can be remedied by Parliament. And then finally, if we can turn up Lord Briggs' dissenting judgment, which starts at paragraph 93 on page 303, and 5 lines up from the bottom of paragraph 93, he says, it was hoped that this new start would close off many of the loopholes through which advisors had previously been able to guide their clients. It is no surprise that in its infancy, SDLT proved to have its own unintended loopholes. During its first decade, it's therefore been the subject of frequent tweaking and revision. And then over the page, page 307, paragraph 109, he explains there that if the revenue are right, then it means that the sale of the Chelsea Barracks is exempt from SDLT, whereas if his interpretation is adopted, there is a single charge to SDLT on the sale to the bank. And he says this between letters B and C. The second outcome, in other words, his interpretation, accords with the overall purpose of Part 4 to charge SDLT on purchases of land in the UK with the avoidance of double tax on a subsale and with the objective of Section 71A. And then he says a choice under Section 45(5)A, which in this context produces an unintended tax holiday for all the participants in the purchase viewed as a whole, is simply not one permitted by the context, where the alternative choice produces a result broadly in accordance with the purpose of the legislation. So again, an acknowledgement that even though, or that he is acknowledging or embracing the fact that the upshot of the revenues interpretation is to produce an unintended tax holiday, but nonetheless, that was the interpretation that prevailed in Project Blue. So if, as in this case, the legislation results in an unintended loophole, we say it is for Parliament to legislate, which it could easily do, as the Upper Tribunal observes in paragraph 160, by defining the period of 3 years immediately preceding, or defining the period as the period of 3 years immediately preceding and including the effective date of the transaction. And in the grand scheme of anomalies, the anomaly in this case is relatively benign, we say, because, or certainly compared with Project Blue, in this instance, the consequence of leaving out of account any prior transaction which takes place on the effective date of the distribution simply means that the ordinary rule that SDLT is chargeable on the consideration given applies. And we say there will always be an element of arbitrariness in the operation of a rule which depends upon the occurrence of an event within a specified period of time. So 2 final points, if I may. First, reliance is placed on the explanatory note to clause 54 of the Finance Bill, which is at page 561. This is the note to clause 54, which deals with the exceptions from the Dean Market Value Rule. And paragraph 5 says subsection 4 provides an exception where the vendor is a company and the transaction relates to the distribution of assets, including a distribution made in connection with the winding up of a company. It does not apply if the vendor has claimed group relief for the land on a transaction that has taken place in the 3 years prior to the transaction. So the purpose of the explanatory note is to explain in general layman's terms what the provision is getting at. But it cannot sensibly be said that it should be read without reference to or otherwise than in conjunction with the legislation itself. And in particular, the fact that the explanatory note omits the words effective date does not entitle you to ignore those words when interpreting and applying the actual legislation. So,
And the primary source is the words of the statute.
absolutely, absolutely. So the note does not, the explanatory note does not use the words of the statute. And then finally, and contrary to what is suggested in paragraph 35.2 of the revenue skeleton, the existence of an anomaly or a loophole is not a basis on which to read words in this instance, the words and including, so as to bring the effective date of the distribution transaction within the 3-year period. Now, the revenue rely in support of the proposition that you can read words in on O'Rourke and Binks, which is at page 242. And we say the circumstances in O'Rourke and Binks were very different to the circumstances of the present case. So the provision at issue in O'Rourke and Binks was section 72.4 of the Capital Gains Tax Act 1979, which dealt with the computation of chargeable gains on a capital distribution and provided for the amount of the distribution to be reduced by the base cost of the shares. And the question was whether section 72.4 should be read as limited to the situation where the capital distribution was small in comparison to the value of the shares, as was expressly the case in section 72.2, which was the provision which enabled the revenue to disregard the disposal and instead deduct the amount of the distribution from the base cost. So tax on the distribution would be payable on a subsequent disposal of the shares. Or alternatively, whether 72.4 applied regardless of the size of the distribution. So was 72.4 to be read as limited to the same scenario referred to in 72.2, or did 72.4 apply regardless of the size of the distribution? And you can see held in the head note, the natural construction of 72.4 in its statutory context was that it was limited to cases where the amount of capital distribution was comparatively small. However, the absence of any express limitation of 72.4 to small distributions made it possible to treat the subsection as applicable to all distributions, whatever the size. And then skipping a sentence, so that meant that the provision was, there was ambiguity. That ambiguity could be resolved by taking into account the anomalies produced, the comparable provisions in the 1979 Act, and the antecedent legislation. By that process of interpretation, effect could be given to the presumed intention of the legislature by implying into 72(4) the limitation intended by the legislature. Thus, 72(4) should be read as though, after the word where, the limitation in a case in which the amount distributed is small compared with the value of the shares in respect of which it is distributed, were included. So there's no carte blanche to read words in, even in the case where the result is anomalous or absurd. In Binks, that interpretation, which did involve reading words in, was justified on the basis that the particular words of limitation were used expressly in an earlier subsection, 72(2), which itself was referred to in 72(4), and where the antecedent legislation demonstrated that the limitation was intended to be included in 72(4) as well. So Binks was a case which, as Lord Justice Scott puts it, all the signposts point in the same direction and confirm the first impression that 72(4) is intended to be limited to comparatively small distributions. And so we say Binks does not assist the revenue in this case because there are no such signposts in this instance.
And would you say also here there's no ambiguity?
We say exactly. It's only capable of one interpretation.
It's only, and this was all applied because there was an ambiguity on the face of it.
Yes. So those are my submissions, unless you have any further questions.
No, thank you very much indeed. Mr. Henderson.
Good morning.
Good morning. Or good afternoon.
Afternoon, actually. I intend to make my submissions on the appellant's two grounds in the same order in which my learned friend has taken them. So first address you on their ground one. Has there been a transaction in respect of which group relief was claimed by the vendor? And then the ground two, the 3-year period issue. So starting with the claim issue, my learned friends explained, I have to apologise, my voice is almost gone, but I'll try and keep going. My learned friends explained how this fits into the arguments, but just to recap, the land transaction we're concerned with at this point is the assignment of the lease from B64 to the appellant. B64 and the appellant are connected companies, so prima facie, section 53 applies to deem a market value consideration for that transaction, or not less than market value consideration. But the appellant argues that one of the carve-outs to the market value charge in section 54 applies, and the carve-out they rely on is case 3 of section 54. And we've already looked at that, but that says it must not be the case, the provider to the carve-out said it must not be the case that the subject matter of the transaction or an interest from which that interest has derived has, within the period of 3 years immediately preceding the effective date of the transaction, been the subject of a transaction in respect of which group relief was claimed by the vendor. So, what does in respect of which group relief was claimed by the vendor mean? And as you know, HMRC's case on this issue is very straightforward and in my submission correct. A land transaction return was filed by B64 in respect of the initial grant of the lease by SGSL to B64. My learned friend's shown you some of the returns. This is recorded at paragraph 20 of the FTT's decision. And in that return, group relief was claimed. And group relief does need to be claimed. It's perhaps worth looking at the provision on that again, section 62 of the FA 2003, which is on page 57 of the authorities bundle. And this formulation is replicated in different parts of the FA 2003, depending on which particular relief is being considered, although there are some claims that are made outside a land transaction return. We don't need to concern ourselves with those. But relevantly, subsection 3, any relief under that schedule must be claimed in a land transaction return or an amendment to such a return. So, B64 claimed that there was no SDLT to pay on the grant of the lease of the tower to it because group relief applied. And making that claim was B64's choice. And having made the claim, B64 had to include a declaration on the land transaction return that the return is, to the best of its knowledge, correct and complete. My learned friend said, unfortunately, we don't have Schedule 10 in the bundle, but I can hand you up the first paragraph of Schedule 10, just so you can see that. My submission, this is an important obligation which is consistent with the obligation under self-assessment in a direct tax context. And our main submission is that that is the end of it, because section 54 is clear. B64 was the vendor when the lease was assigned to the appellant, and the lease had been the subject matter of a transaction in respect of which group relief was claimed. And in terms of why Parliament may have laid down such a test, it is important, in my submission, to recognise that SDLT is a self-assessed tax. That means it's the responsibility of the taxpayer to make the necessary land transaction return. That's section 76 of the Finance Act 2003, which is on page 78 of the authorities bundle. Calculate the correct amount of tax that's due. That's section 76, subsection 3. Pay the tax in respect of the land transaction not later than the filing date for the land transaction return. That's section 86(1), which is on page 89 of the bundle. And this used to be 30 days, it's now 14 days from the effective date of the transaction. And the filing date, you can see that time limit in section 76(1), on page 78. So the primary obligation to ensure that the correct amount of SDLT is paid falls on the taxpayer. And I'm sure it hasn't escaped your notice, but there is a certain irony in this case that the appellant at this stage are now saying that HMRC should have recovered the SDLT on the grant of the lease to B64. But until this level, the appellant has, as you know, fought very hard, suggesting that B60, that group relief was available to the appellant. I'll come on to make a point about how that correlates to B64 in a minute, but up until this level, they fought hard to suggest that group relief was available. But going back to the background to all of this, every year there will be thousands of land transaction returns submitted. That means that the vast majority of the returns will not be inquired into. And as I've said, the onus is on the taxpayers to complete their land transaction returns correctly. And they have a responsibility for getting it right, and if, because it turns out they actually had a main purpose of avoiding tax, and they're caught by paragraph 2.4a, come on to that, then my submission, so be it. Now, the appellant submits that the reference to the claim for group relief in section 54.4b must be read as referring to a valid and effective claim for group relief. But I make the simple point, as we do in our skeleton, that if Parliament had intended that it had to be a valid or an effective claim, then Parliament would have made it clear, and that's a point my Lady Justice Falk made in the permission decision. And a similar point was made to that in the FTT decision at paragraph 74. Also, we say in our skeleton, on the appellant's approach, it's not clear when and how the validity and effectiveness of the group relief claim would fall to be ascertained. Is a challenge by HMRC sufficient? Or what if that challenge is overturned on appeal? And it can't be the case, in my submission, that the proviso is engaged and then disengaged in that way, depending on events, such that whether the exception applies cannot be determined at the time the distribution is made. And of course, in most cases, on controversial cases, it will be obvious whether or not the connected company has made a group relief claim, a valid group relief claim.
You're pointing to difficulties for the taxpayer who's got the responsibility to make the return to know whether group relief was available or not on some earlier transaction.
Yes.
But doesn't the taxpayer face difficulties of that kind all the time? For example, in determining whether group relief is available on the current transaction. I mean, the reality is that legislation is not simple, and it's very often the case that you have to file a tax return which makes assumptions or proceeds on a particular basis which could well include what may or may not have been the correct tax treatment of an earlier transaction. Isn't it just one of a number of uncertainties that taxpayers have to address?
Taxpayers obviously have to address difficulties in filling out their tax returns, but both in direct tax and SDLT, they have got to fill out their tax returns on the basis they think is the correct basis.
Hence the best of their knowledge and belief.
Yes.
So you do it on that basis.
Yes,
And the legislation also provides for later amendments,
it does.
which might deal with a point being made about withdrawals of claims on the earlier transaction.
I was going to come on to the amendment point, but yes, there are inevitably provisions for amendments. I think the time limit for SDLT is 12 months. But my lady, the point you've raised leads me to this point that I was about to make, because the appellant's interpretation in my submission throws up another difficulty. Quite accept that sometimes there are difficulties in deciding how to fill out one's own tax return. But there was an exchange a little while ago between my lady and my learned friend, and it was said that based on the decisions of the FTT and the Upper Tribunal, it's now clear that the appellant was not entitled to group relief. The appellant. It was then discussed that presumably you can extrapolate that the same analysis would have applied to deny B64 group relief. Now, in this case, that might well be correct, and I'm not going to seek to argue otherwise. But one can imagine cases where the group relief status of another taxpayer is not nearly so clear-cut, even with the benefit of hindsight, as it were, when the second taxpayer's affairs are being considered, for example, in a tribunal decision. We know that in the group relief schedule, as well as there being a main tax avoidance provision that prevents group relief applying, it's also necessary that the transaction has been effected for bona fide commercial purposes, commercial reasons, I think it is. There might be different considerations on such a provision applying to a company like B64 in our case, as compared with the appellant.
Sorry, you're focusing there on bona fide.
So in take you to it, in Schedule 7, paragraph 24A on page 131 of the authorities bundle, it says group relief is not available if the transaction is not effective for bona fide commercial reasons, or B, forms part of arrangements of which the main purpose, or one of the main purposes, is the avoidance of liability to tax. And what I'm saying is that in this case, the focus has been on B in relation to the appellant. What I'm saying is it's too easy in this case to say, oh, well, because the appellant has lost its fight on group relief, the same answer must apply to B64. And as I say, maybe it does. But in other cases, it'll be far less clear-cut. And the appellant's interpretation of sort of keeping this question open by saying it has to be a valid and effective group relief claim is going to get everyone into a complete muddle, because it's never going to be clear what criteria one looks to judge the other company and at what point. By contrast, HMRC's interpretation, which is grounded in the obligation of every taxpayer to fill out their SDLT return correctly as far as they can, provides a simple test, which in the vast majority of cases will be the end of the matter.
I mean, even HMRC's interpretation requires a company in the position of the appellant to know something about, in this case, B64's internal affairs.
Yes, but
in particular, how it filled in a tax return.
Yes, but they're connected companies by their very nature, so one must assume that they
but
have lines of
can't
communication.
you then take that argument further? Because you're trying to rely on the fact that there's a different company and it all gets too complicated, but there is some need to get information from B64, or the company in the position of B64 in any event, isn't there?
There is, but we are balancing, on the one hand, the very, in my submission, likely answer, which is that B64 would be forthcoming as to whether it would claim group relief or not. I mean, and I keep talking about B64, it could be another scenario.
No, I started that off. I'm using it for convenience.
Yeah, so it just helps
keep
fix which company is which, but let's call them Company A, Company B. They're connected. Yes, Company A has to inform Company B that they've made a claim for group relief. I would submit the difficulties arising from that might not, that Company B might not be able to ascertain that, are going to be minimal compared to the sort of difficulties that I'm outlining, where this question of whether group relief has been claimed remains in abeyance, in this case, for years. It was in abeyance in the FTT and the Upper Tribunal. It makes no sense to have a test like that, particularly in circumstances where the obligation is on the taxpayer to fill out their SDLT return shortly after the chargeable transaction. And we make a further point, which goes to paragraph in the Upper Tribunal decision. Could we go to paragraph 165, please? Of the core bundle.
Page 99.
Oh, hang on, I've got the... Yes, 99, you're quite right, sorry. Paragraph 165. So 165 says, whilst Ms. Shaw submitted it is factually incorrect to say that the claim for group relief was made and in practice succeeded, drawing attention to HMRC's conclusion that group relief was not available to Tower 1 on the subsequent transaction, and that HMRC had proceeded on the basis that sub-sale relief was instead available, we consider that viewed realistically, the facts were that B64 made a claim for group relief and has not paid SDLT on the grant of the Tower lease, and that this is within the class of facts intended to be captured by the proviso to the case 3 exception. So in the present case, as the Upper Tribunal notes, B64 made a claim for group relief, they've never withdrawn it, and as a result of that claim, they have paid no SDLT on the transaction whereby the lease was granted to them.
Sorry, you say as a result of that claim?
Well, if they hadn't made that claim, then they would have had to fill out their SDLT return on a different basis. Now maybe they would have said at that point, well, sub-sale relief applies, or something like that. Maybe they wouldn't, I don't know. But those are the candidates. But they claim to be exempt from SDLT because of group relief. Now, it's true that HMRC took the view that sub-sale relief under section 45 was available to B64. And that would have meant, as my learned friend explained, that the grant of the lease by SGSL to B64 would have been disregarded as taking it. But the FTT, of course, decided that sub-sale relief was not available, therefore disagreeing with HMRC's position. And I say the fact then still remains that B64 claimed group relief on its land transaction return and has had the benefit of that claim. So we say, even on the appellant's interpretation of section 54(4), which we submit is wrong, B64 has made a successful claim for group relief. It made the claim and it's not paid tax. But in any event, that is a secondary submission. And HMRC's primary submission is that section 54(4) means what it says. The lease was the subject of a transaction in respect of which group relief was claimed by B64. And although my learned friend seeks to assert connections, for example, with Schedule 7 and so on, those are the simple words of the legislation, and she hasn't pointed to any materials that support her thesis that claim must mean valid and effective claim.
Well, can I ask you this question? The 3-year rule does seem to be obviously explicable by reference to paragraph 3 of Schedule 7. Do you have any other explanation for the 3-year time period?
Well, while we were listening to my learned friend's submissions this morning, I did ask those behind me, are there other examples of 3 years being a relevant period within the SDLT code? I'm sure we could find others, but there was one referred to paragraph 2 of Schedule 8, which is the charity relief.
Well, okay, but...
Well, I'm just making the point that 3 years isn't specific just to these two provisions. There are other provisions within the code where a 3-year period is used. So then, turning to the points made by my learned friend on this aspect, she's asserted that the purpose of Section 54.4, the proviso to Section 54.4 in Case 3, is to prevent groups from sidestepping the clawback of group relief by distributing the profit to another group company and then selling the shares. But, as I say, there's been no reference to any actual materials, explanatory notes, anything like that, to make good that proposition. It's just assertion as to what must have been sort of the thing in mind. And I say that Section 54.4b is a very clear test that certain circumstances will avoid a distribution being within the let out from the Section 53 charge. It's just telling you what transactions won't benefit from that carve out. And on my learned friend's thesis about, well, this is all to do with distributing up to a company to sidestep the clawback provisions, even on the appellant's interpretation, the proviso to Case 3 would apply even if there was no sale of the shares of the group company to which the property has been distributed. So the mischief that my learned friends identified doesn't form part of the statutory test. It's not a condition of the proviso that there's then a sale of the shares to a third party or anything like that. And as my lady points out,
isn't the point being made that it's getting round? I thought the point was being made that it was designed to deal with a situation where there wasn't a sale of the shares of the company, because that would engage clawback, rather some other transaction taking the form of a distribution that avoided.
but there could presumably, the mischief that my learned friend would identify is you distribute up. So it's not the original company that leaves the group. You distribute it up to another company, and then there's a sale on. And all I'm saying is there isn't anything in Section 54.4 that suggests that that has to be part of the arrangements for this proviso to apply. And as I said, there's been no materials to make good this supposition. And there is no motive test in Section 54.4. It just tells you the circumstances in which the carve-out to the market value charge will not apply. And that's replicated across SDLT legislation. It often says if you enter into these sorts of transactions, then the following consequences will apply. And let's assume, for example, that the appellant's group did want to try to sidestep group relief, clawback provisions. I'm not suggesting they did. I know this is all done for corporation tax avoidance purposes. Let's assume that they did want to sidestep group relief clawback, as the appellant suggests is the purpose of this provision. Standing back from it, they might have done some transactions very similar to the transactions they actually did. We've got a distribution up within the group. So how is it that the proviso has to be read as if there's some sort of underlying motive test to it? It's just setting out the transactions that you need to avoid if you want to avoid the proviso. And I say the proviso has to therefore be given its natural meaning, and in the context of the fact that SDLT is a self-assessed tax, that natural meaning makes a lot of sense in my submission. Now, at paragraph 41 of the appellant's skeleton argument, and it was repeated again this morning, the appellant complains that SDLT has already been paid at various other points in the transactions. I think reference was made to SDLT having been paid on the acquisition of the land in the first place. Well, in my submission, that also doesn't assist the appellant's case, because the transactions, as we know, were structured with a view to corporation tax avoidance. And if they hadn't done those transactions, we wouldn't be here now. And it's no good saying Section 53 is akin to an anti-avoidance provision. It's not an anti-avoidance provision in the sense of having any kind of motive test or anything like that. You have my point on that. In my learned friend's skeleton, they refer to us at paragraph 43. They refer to a statement by the Chief Secretary of the Treasury, where he said, we want to look at the substance rather than the form. Can I just show you that very briefly? It's in the authorities bundle at 569. It's the last big size paragraph, which begins chargeable to stamp duty, and there's a reference to Schedule 4, and about 4 lines down, we want to look at the substance rather than the form. Well, I just say on that, it's not possible. That was a discussion in the context of discussing whether the SDLT position, where a purchaser is committed to use a vendor for particular works, and there's a reference back to an old case called Prudential, a stamp duty case. And I say that just referring to that doesn't assist the appellants in this case.
Have we got the context that gives us that? No, we don't. Oh, sorry, Schedule 4. You say it's in the context of the Schedule 4.
Yes, there's a discussion about how SDLT might work where you have contracts for land with also construction works attached. My submission, you can't extrapolate from that discussion anything useful for the debate in this case. I noticed the time.
I was going to think, is it a convenient moment for you?
It is, yes, thank you.
Thank you. And we're doing quite well, I think.
I think so, yeah.
Okay. So 2 o'clock, thank you very much.
All rise, please.